presents a couple of unusual situations. This is one in which the staff agreed that it was admissible. However, the applicant has filed for information recently, which it asserts in effect renders Contention 7 moot, because you do address the things that are challenged in Contention 7.
The information at issue has been classified as SUNSI, S-U-N-S-I, and we've made an application to get access to it under that provision. We haven't gotten a response to that application for access as of yet. So we don't know, frankly, whether what's been submitted is consistent with what's required under the regulatory provisions or not, or whether it's arguable even.
Judge, Jim Biggins for the staff again. We are currently reviewing that SUNSI access request. I would point out that that is not a matter for decision by this board according to the order that was attached to the Federal Register Notice of Hearing. Once the staff makes its determination, according to that order, there is a specific period of time, I believe it's 25 days, for filing a contention based on the information. And so the staff's position is that both the staff, the applicant, and the petitioners are all bound by the terms of that order. And
again, we're operating under the assumption that we're going to get access.
What is the provision in the order, if any, about the circumstances of the appeal of the staff's order if it were to be a denial?
If the staff denies the request, the petitioner, or as the order calls them, the requester, has the opportunity to appeal the staff's decision, and that appeal would likely be referred to this board for consideration. The question specifically asking what the significance of the filing is. And the staff's position originally on Contention 7 was that it was admissible in part. However, the staff position now is that with the filing, the contention is now moot. The portion that was admissible is moot.
But that's based on the information that we don't have now, right? So do you want to...
Well, the staff has that information and believes that the information meets at least filing requirements for the rule itself. Similar to a docketing decision, the staff would reserve the right to ask RAIs of the applicant as necessary, but we believe the information moots the contention, which was one purely of omission. The contention was essentially that there was a new rule, the information was not provided as required by the rule. The staff's position is that the information has now been provided, and therefore that contention itself is moot. If, as new information, a new contention could be crafted by the petitioners, obviously that would fall under the criteria for relief of contention. The staff position is that it is a staff determination whether or not the petitioners receive access to the SUNSI information. Yes, that is reviewable by the board should it be denied and appealed. However, the board has to consider the situation where if SUNSI access is denied and the board were to uphold that determination, then this contention would have to be ruled on by the board without allowing access to the petitioners to the information.
Let's assume that possibility were to occur.
Sure.
Is there really any reason to make that determination now based on the possibility that we might get to that point rather than waiting to that point and having that brief? Because we're talking about an extremely unusual situation where any forum would render a decision where all parties do not have access to the information, and we're being asked to do that in the absence of further briefing on the possibility that we might get to a point where we would rule that the petitioner should not have access to this? I mean, do you realize what you're arguing here?
I do, Judge.